You know this man across the English-speaking world. His analysis of legal matters is celebrated and craved. I'm talking about London radio and television, Australia, New Zealand, in New York, in Chicago, in San Francisco, and Los Angeles. We are so lucky to have regular visits with this guy who breaks the law down like none other. He is the former federal prosecutor. Now he works as a defense attorney in Southern California. How about it for the great David Katz, everyone?
Great Hello, to be with you.
David, there's a lot going on. I want to start with the Supreme Court, if we might. This is a big decision that was producing a lot of anxiety about Mifepristone, the abortion pill, just to, as it's referred to. And it's the pill used by over 50% of those wanting to have an abortion, and it can be, you can get it through the mail. So it's in front of the Supreme Court, and they now have allowed it to continue to be accessible. But they did it, I think, David, and this is the question I have for you, on the standing of that party that brought the case to the Supreme Court. Can you explain standing again to us? And also, perhaps more importantly, does this then leave it open for Mifepristone to be blocked in the future?
Well, Mark, this is the abortion medication. This is the pill. This is the way more than half the women in America get an abortion, not by going in for a procedure, but by taking this pill. It would have had devastating effects if the U.S. Supreme Court had gone the other way. It would have affected women in blue states, where I think a lot of women and men think that maybe they're far away from this madness emanating from the U.S. Supreme Court since Dobbs and since they overruled Roe v. Wade. I also want to take a victory lap, Mark, because I predicted this a couple of times, this outcome, and I suggested it would be at least 7-2. And we joked around that the U.S. Supreme Court would show its big pharma side and not its theocratic side. The standing was actually, this case had poor standing ever since the beginning. In Scalia's famous saying, Justice Antonin Scalia, "What's in it for you? What's your beef? Why are you a player in this game? Why aren't you just a fan who ran on the field? Why are you a player in this game?" And these doctors who brought this lawsuit were obviously not players in the game. This was the case that was cherry-picked. It was run to a federal judge in Amarillo, Texas. You can think of all the things a federal judge should be known for. First in her class, brilliant judgment. This one was known and picked by Trump because he was a Christian warrior. And the case was shopped to this judge in Amarillo, Texas, who purported to enter a nationwide injunction against this pill. And I predicted that pill, that injunction would not last. It would not go into effect. You'll recall the U.S. Supreme Court did not let it go into effect. There have been no restrictions on this medical abortion pill for all of the time leading up to this. And at the time of the oral argument, Mark, it was pretty clear that these doctors didn't have standing. Their argument is that in an emergency, they might be the one in the ER, and they might be forced against their conscience to go perform some emergency procedure because someone had taken this medical abortion bill, and therefore they had standing to complain about it. As Justice Kavanaugh said in the unanimous decision today, there's a medical conscience bill. So if you really are a doctor in that situation, you don't have to perform any kind of procedure that's against your religion. Obviously, the precaution is have somebody who doesn't have your religious moral views on duty in case that happens. But it was statistically so improbable. It was such a stretch to get to that standing that probably only that judge in Amarillo, Texas, would have accepted this as proper standing in the first place. And although it seems very technical, there is an idea that you have to have a lawsuit that's really joined, that's really fought, that's really a case that's going to make both sides put their best foot forward and make every argument that can be made. And a person without standing is, first of all, unlikely to make the best arguments. And so it won't be well decided, and it will become precedent after the best arguments aren't made. And then people say, well, no, it's worse than that. It's really kind of a conservative vehicle to stop the public interest groups from raising issues. And the argument goes, wait a second, if the law is wrong, if this shouldn't be the law of the land, why shouldn't some public interest group be able to challenge it? Standing or no standing, if the law is wrong, why not be able to bring it up? But for decades now, we've had this doctrine. It's often used as a way to cut back on liberal groups. But guess what? Here, what's good for the goose is good for the gander. Here it was this very right-wing effort by these doctors trying to shop this case into a particular courtroom in Amarillo, Texas, albeit a federal courtroom, and they came up completely with bupkis, with zilch, with nothing on account of all this. Now, the question that you're going to ask me next, and I guess you did ask me, is who is the proper plaintiff? Who is a player in this game and not just a fan who ran on the field and started saying, wait a second, I don't like this law. I don't like what's going on over here. That's going to be actually very difficult because it would have to be somebody who the FDA told them what to do or told them what not to do. These doctors are not regulated by the FDA. Whether Mifepristone is a legal drug or not in blue states and red states, whether the FDA properly engaged in this analysis that these expert agencies like the Food and Drug Administration engage in, there has to be some action that actually they're told to do or told not to do. So that's why I think Kavanaugh said as a sop to these plaintiffs, well, you can always go to the legislative process or like get Congress to pass a bill. You can always go to the regulatory process, try to bring this next time this comes up to try to have the FDA analyze, let's say, a new version of this pill. But the reality of this, Mark, I see this whole thing is totally made up, totally nonsense. The FDA is an expert agency. They did all the tests. It's too long ago when they first allowed this drug on the market. They can't complain about the drug being on the market. But then they did revise the rules so that you could get it by telemedicine, so that you could get it without having to go to a doctor, because sometimes the doctor's 200 miles away. So it's quite a restriction to make you go to the doctor or not get it by telemedicine. That was the new one. That was the one that it looked like might actually be in trouble of being enjoined and affecting the blue states. That's not happening. So all I can say is that the next time this comes up with maybe something that makes it even easier to get this medical abortion, that's when the right wing will take their crack at the FDA. And even let's say if Trump is back in office, even if Trump has appointed the head of the FDA, I don't see this happening because, again, that's the issue we started with. That's big pharma. They have billions of dollars invested. If you can do this to the makers of this drug, you could do it to the makers of the cancer drugs, the blockers, everything else. Billions of dollars are invested. Big pharma is way behind this. The idea that some judge or even some appellate court somewhere in the federal system can block that drug and suddenly make it unmarketable or unsaleable throughout the nation, or even in that particular appellate area where that court is, I don't think the U.S. Supreme Court's going to buy into this. Even if Trump's in office, even with this U.S. Supreme Court that we have, I think this is going nowhere.
So women will have access to Mifepristone for all the wrong reasons, it sounds like, basically, because of the power of big pharma to protect it.
Sometimes the way you get there is not as important as that you get there. And in this instance, this involves so many women, their lives. It's often poor women. It's often minority women. It's women who have nowhere else to turn. It's women who are in Louisiana or in the South and can't get off work or can't get the money or can't get a car to drive them hundreds of miles. They can get this at the local pharmacy. And they can get it prescribed by telemedicine. And besides, I don't think it's not one of those just the ends justify the means. The standing doctrine is good for the goose and good for the gander. It stopped an awful lot of challenges from liberal groups. So it stopped a challenge from a right-wing group that really didn't have standing. They really didn't have a dog in this fight, except they were an advocacy group that desperately wanted to be in this fight against women's right to choose, even to choose a pill.
David Katz, that comes from SCOTUS and the attempt to get SCOTUS to adhere to enforceable ethics regulations or guidelines. That has been derailed. It was derailed by one senator, Lindsey Graham, today. We're just talking about it. I wonder if you can give me some thoughts on that. It's an odd place that legislators find themselves in when they don't want to back any kind of guidelines that are enforceable for the Supreme Court.
Well, I'm not so sure with the separation of powers how far the legislative branch, that is Congress, can really go in imposing rules. And I know I sound like an idealist, but we need checks and balances. So in this instance, maybe we need a check and balance that comes from the U.S. Supreme Court itself. People are very loath to have restrictions on their own conduct, right? We've all seen that hypocrisy. People think that, well, this is great, we should have rules and regulations for that. Some of the most rules-oriented people, when it comes to their own conduct, Mark, haven't we all seen that? This hypocrisy that they then do not want to actually be reined in by rules that they think are so great for other people. Well, the U.S. Supreme Court's 9 human beings, and under our system of checks and balances, it's very hard to see what, lower federal judges, I just said it, they're lower federal judges. They can't tell the U.S. Supreme Court what to do. And other branches of government, it's very hard. I said this before, you can get prosecuted for income tax violation or other kind of crimes if you're a U.S. Supreme Court justice. That does not violate the separation of powers. We've seen senators who are members of the legislative branch criminally investigated by the executive branch. We've seen some federal judges, let's say, who haven't paid their taxes at all or have major criminal federal problems. We've seen them not only prosecuted, but we've seen them impeached. Those are actually some of the impeachment cases that we've seen. And there've been a lot written about the gifts that Thomas took. What are the possible criminal implications? What are the federal income tax implications of what Thomas has done in particular? And I leave that to other people who may have investigated it. But I don't think it's a good precedent. I don't think the way to solve this problem is that every now and then we have an attorney general of one party going after a U.S. Supreme Court justice that was picked by the other party. Boy, that does look a little bit like a banana republic, in countries like Hungary and so forth. Certainly in Russia, the judiciary is totally emasculated. And they end up being completely at the whim of political figures who always threaten them with some kind of criminal prosecution, right? So I don't like that system, but it is very hard to see if the U.S. Supreme Court doesn't endorse ethics rules for itself, how we really get there to an enforceable system. People say, why don't you write to the Chief Justice? He has the title of the Chief Justice, but he has no reign or sway over the other 8, any more than Thomas has sway over the Chief Justice. Does the Chief Justice have sway over Thomas?
That's wild. I mean, it's just that last part where the Chief Justice essentially has, he couldn't impose ethical guidelines that would be, enforceable in any way. It's fascinating to see the open corruption that we become aware of, David, both in terms of the monies taken and gifts received, but also the open corruption when it comes to the flags above the Alito house, the comments of Alito and his wife, the 2 wives. I don't mean to make this about the wives necessarily, but it is wild. Clarence Thomas's wife was involved in the effort around J6, and Alito's wife very much flying the flags above the Alito house. I believe that he was involved in that as well. But that said, that you can't even get them to consider recusal on such matters, even though, they have made their feelings on these things clear, at least by proxy, through their wives and through their actions and statements.
I was stunned by Mrs. Alito's comments. First of all, if you talk to someone at, the U.S. Supreme Court Historical Association, where all these random people are there, even if they are vetted, you don't talk to people who are, quote, vetted as openly. Mrs. Alito and Justice Alito didn't really know that lady from Adam. And here they are talking about all of those things. They're very public figures. I find no fault at all. Justice Alito never ran into a sting that he didn't like. If this had been done against any kind of, low-level grifter, they would have thought this was the greatest thing in the world, all fun and games. Remember like on NYPD Blue, where they always had some clever way to get the skell to talk and to avoid him having a lawyer and to do some clever undercover thing. Well, as I say, Alito loves all that. Well, what goes around comes around. So somebody wore a wire on him. I think it was even legal in that situation. I don't think that there's a one party, because I'm not sure in Washington, D.C. or where the function was held. But Mrs. Alito's comments out of her own mouth, she wasn't agreeing like Justice Alito was with a comment about, we need to return to godliness or whatever it was that she said, and then he affirmed that. Okay, but she, out of her mouth, as I understand it, Mrs. Alito, to basically a complete stranger, said about the feminazis. That's just
right.
unbelievable that a U.S. Supreme Court justice's wife would call people feminazis. That's what Rush Limbaugh's old term. It's incredibly demeaning, incredibly unfair to call anybody a Nazi. If you go and you call Trump a Nazi and you say that things he did were comparable to things that Hitler did, he rose to power, people just go out of their minds. And then a U.S. Supreme Court justice just glibly calls women that she doesn't agree with politically feminazis. To me, that was astounding.
And for those who don't know, she talked about those who are critics as feminazis. She described her critics as feminazis. That's what David's talking to. And she threatened libel lawsuits against the press. She reacted to all of this. And she also, you get this toxic resentment from her. She said, I want to, because she didn't want the LGBTQ pride flag flying near their house. She says, I want a Sacred Heart of Jesus flag. This is a quote from her, because I have to look across the lagoon at that pride flag for the next month. When are you free of this nonsense? I'm putting it up. It's a... Yeah, I mean, look, they clearly, there's nothing wrong with the notion of being a fundamentalist religious people, or, I mean, if that's their way, but it seems to inform a lot of their life and now their judicial decisions as well.
Yeah, I just think that it's it's very unfortunate, that if people think, and of course they already do after Dobbs and after so many other decisions, we talk about Chief Justice Roberts as a moderate, and he is a moderate on this court. He's also the author of Citizens United. He's in with the Second Amendment cases that for over 150 years, people thought that the right to bear arms had to do with the militia, which is mentioned in the Second Amendment, along with the right to bear arms. It mentions a militia. So this is Roberts, but I mean, Alito is so far out to the right. One of his comments, we can get on to another topic if you want, but he was blasting ProPublica. Say it again, Mark.
Yeah, ProPublica. Yeah, you had it right.
He was blasting them as they have big donors. Now that is so rich because Salmon Alito, who took that free flight for the salmon fishing up there, there was just room on the plane with some billionaire, so he jumped on there. I don't think he paid for the trip. I don't think he did anything that you or I would have done to have any sort of trip like that. And of course, Thomas took those millions of dollars of private jet, flights and incredibly expensive cruises with his wife. All that money from the right wingers, that right winger who bought some relative's house, who put another relative of Thomas's through school on the billionaire's nickel. And the billionaires, of course, have issues before the U.S. Supreme Court, don't they ever? For Alito to say that, wow, the left-wing organizations have big funders, it's just unbelievable. I mean, he's just supposed to be a smart guy. He seems to have lost all sense of perspective on these kinds of issues.
And just the last thing, then we really will move on. But the idea somehow that I believe, and you can help me remember this, but that he would invoke in his Dobbs decision, he wrote the opinion, a law from hundreds of years ago, and a reference to clearly a religiosity or a belief in the spiritual realm that somehow informs a legal decision that affects America today. It tells you a lot about his biases and how these decisions, how he comes to them. He sort of reverse engineers them and then searches for hundreds of years to find some reference from a judge who believed that, bleeding patients to death was the way to, get them. It's crazy. It's witch hunt stuff.
Yeah. Are we going to get to Hunter Biden? I know it's
Mark, can you do this? Maybe do this on your own time. Yeah, I'm sorry about that.
No, not at all, not at all.
Let's get.
No, I'm going to make news. I'm going to make news on your show because I think that President Biden, no matter what he says, will at the very least commute Hunter Biden's sentence. I think he may actually pardon him, but I think that he will commute his sentence, and I'll tell you why if you'd like.
Please.
I think it's just sort of the chess moves. And one thing, it begins with the Delaware case. The Delaware case, now that he stands guilty, found by the jury, Hunter Biden, the sentencing guidelines, which is, I've heard so many people comment on this and they discuss it politically and philosophically. A lot of it is geared to the federal sentencing guidelines. They were passed in the 80s. The liberals actually backed them. Teddy Kennedy backed them. The idea was it would rein in the hanging judges. It would make them go by some sentencing guidelines. And of course, the Reagan administration that I was working for then was very much in favor of the federal sentencing guidelines because the bleeding heart judges would have to give prison sentences. And basically, the federal sentencing guidelines say that if you get involved in any kind of serious white-collar case, one that the federal government will prosecute in its discretion, you pretty much have to go to jail, unless you have some very extraordinary circumstances called a downward departure from the sentencing guidelines or variance. Or if you cooperate, that was one of the goals, was to get people to cooperate in those cases. So to either make them look at a guideline sentence of 7 or 8 years, or to pass a mandatory minimum that said you have to get 10 years, that would induce somebody to take the risk of testifying against the capo, testifying against the higher up person, even in a dangerous drug ring. 10-year mandatory minimum, 8 to 10 years under the sentencing guidelines. Let me tell you what Louis did, how he told me to bring the drugs in. So that was one of the big things in the sentencing guidelines. One of the things under the sentencing guidelines is you get a couple of points off if you plead guilty. And they have always said forever in all the cases say that they're not burdening your constitutional right to go to trial. They're not punishing you for going to trial, but they are rewarding you every time you don't go to trial because you get these 2 or 3 points off, the 2 points automatically, and usually you get the 3 points off. Hunter Biden is not going to get that. Whatever Hunter Biden did 5 or 6 years ago when he was a crack addict and he signed that form, I think the way the federal judge is going to look at it is, number one, you took down that turned down that sweetheart deal in my court. You did that about a year ago. You can't just blame your lawyer for that. I think in her mind, she's going to think, no, you were a participant in that decision, Hunter, and you turned that down and you decided to take your chances with the prosecutor.
That was an 11th hour move, though. Wasn't the judge involved in that, kind of saying, hey, you should look at this? No?
A lot of people have misinterpreted that. And so I want to talk to that. Let me just finish that one point. So since the sentencing guidelines are 15 to 21 months in prison, almost all the experts agree that Hunter Biden's sentencing guidelines now are 15 to 21 months. He's not going to cooperate, so he's not going to get a departure for that. He didn't, plead guilty, the absolute opposite. And so he's not going to get the 2 or 3 points. He's at 15 to 21 months. I argue to courts all the time, look at the extraordinary post-offense rehabilitation of my client, which is exactly Hunter Biden's argument. Look at him today. Look how much he straightened up his life. It's so commendable. He's not the person he was 5 or 6 years ago. I argue that, I think about as well as you could argue to a federal judge. And I'm not batting 100%. I'm batting below 50% on that argument. I'm probably batting, if you actually count them up, worse than below 50% on that. It's very hard. Judges think everyone has that argument. On a tax case or a white collar case, almost all the cases are 4, 5, 6 years old. That's when the conduct occurred. Then the investigation took a long time. The trials took a long time. Trump isn't the only person in America who's gotten his white collar case delayed a lot. Of course, we're all outraged by, how he's done it and, all that. But it's normal if there's not, the election pending and that on the public interest side, it's normal to have cases delayed 2 or 3 years while they're in court. That's after the couple of years for the investigation. So the defense normally has that argument. So that's why I don't think it's going to go well for Hunter in that sentencing. I don't think there's any reason why the judge is going to say, we also decided about a month or 2 ago to take that case to trial on what I think the judge will say was about a 5 or 10% chance of winning. If everybody in America in federal court took their case to trial with a 5 or 10% chance of winning, we'd have this huge congestion of the courts. And so there is this sense of, look, if you got a case that really was triable, try it. Sure, that's your right. I'm into it. But for Hunter's chances of winning, 2 or 3 days after he signed the form, he was out there trying to get crack again. I know what he's going to say. I know what his defense was. His 5 or 10% chance of winning was that at the time I signed the form, I saw myself as a recovered person, not as an addict. And I saw myself as someone who was not unlawfully using drugs because I wasn't using them today. And if he never tried to get drugs again and he'd gone through a formal rehab, maybe. But when you take the facts of this case, which were known to Hunter and known to his lawyers, and he decided to try this case, I think the judge is going to give him a prison sentence. Now, in the fall, he has to come out here to Los Angeles and appear in front of a very able Trump-picked judge, but very able, very fair, in my experience, in front of that judge. I think he's going to give Hunter an absolutely fair trial, and Hunter's going to go to trial again, isn't he? He's going to go to trial again. There's $1 million of back taxes. I know that people have said there's only a few hundred cases a year. First of all, there's more than a few hundred cases of federal income tax evasion across the country in a year. It's not that unusual, and the amount's not small. You can say the case in Delaware was kind of a one-off. What was that all about? Why did they bring that charge? But the one in Los Angeles is $1 million. Some of it's underreported. They're going to try to prove beyond a reasonable doubt. And in some of the years, Hunter had, it seems like, hundreds of thousands of dollars in gross income and didn't even file a return. Those cases get prosecuted. Mark, he can't say this is something anomalous. So that leaves President Biden in a situation where his son is likely to have a prison term, and he will be able to do something about it after the election in November. Let's take two different scenarios. Biden loses. The idea that Biden is going to let his son go off to federal prison with Trump in office, with Trump appointing the head of the Department of Justice, with Trump appointing the head of the Bureau of Prisons. If you remember how Trump just about tortured Michael Cohen, how he made Michael Cohen try to give up his First Amendment rights so he could get out of prison a little bit earlier when the prisons were full of COVID, when Cohen was facing a death sentence. When Biden looks at that and thinks, wow, Trump's going to be in power, pointing the head of the Bureau of Prisons, and my son's going to be in prison. I'm going to drive up to the prison every other weekend to visit my son in prison when I could have commuted his sentence. Boy, I don't see it. And if Biden wins, that's a different kettle of fish. Maybe if his son doesn't get any prison time, he'll wait it out. But again, I just don't see him being president in his second term and going to visit his son in prison when he could have done something about it. Two more thoughts on that. Clinton, pardoned his half-brother, didn't he? And there's a pardon power. And if you don't use it for your own son in this situation, his son didn't kill anybody. He didn't there's no violence. There's no nothing like that. There's no betrayal of the national anything like there is in the Mar-a-Lago case as to Trump. Boy, I just don't see how, if there's a pardon power, which there is, and it basically can be used for any purpose. I think also Joe Biden will have immense pressure from the rest of the family, just as I think Clinton probably had when Clinton issued the pardon to his half-brother. I just don't see it. So that's the news that I'm making. Now, can we go back to Delaware?
No, stop. My God, I think you just absolutely made a lead pipe cinch case for why Hunter would be pardoned. There's, in both scenarios, I'm just doing this for myself. The information from you comes quickly. I just like to review it for myself. The notion that if he loses, that he would pardon Hunter makes total sense, 100% sense. Like, why wouldn't you have nothing to lose at that point?
He's going to leave to Trump's tender mercies. He's going to leave his son to Trump's tender mercies.
You. And then the other point that you make is, and if he wins, at that point, you have nothing to lose either. I mean, I kind of feel like, I don't know. I see the pardon of Hunter as inevitability. And now just my quick question. So thank you. I think you made a really good case for that. I mean, meaning a case for the prediction. Tell me what the difference between a commutation and a pardon is.
The commutation just knocks out the prison term. It leaves all the other conditions of the conviction in place. So if you can't have a gun, you still can't have a gun. If you have 3 years of probation supervision, you still have 3 years of probation supervision. The commutation just knocks out the served time in prison part of it. Let me just talk about Delaware, because this has been spun so much. And I have political preferences like everyone else. I supported Biden. I supported Biden over Sanders. I thought he was the guy who could beat Trump. When he was at 7%, Mark, I'm on the air with people like snickering at me, and I'm supporting Biden. I support Biden against Sanders supporters. I supported him all the time against the right wing. They used to pair me off, and they would snicker at me about Biden. I thought Biden was the right guy. I thought Biden would win. I'm all in for Biden this time politically. Okay. But I just think that's my opinion on that. And I think one thing that's so strange to me is that Hunter Biden has been acting like a guy who knows he's going to get a pardon or feels very, very strongly he's going to get a pardon. And let me say why. I am a federal criminal defense attorney. Between this and being a prosecutor, Mark, I've done this for 35 years, okay? I've seen people on both sides of the aisle face these situations. The sweetheart deal in Delaware was so sweet. It is very hard to understand how any competent, smart attorney would have done anything except say yes. Quickly, yes. He was going to get the case that's pending now in Los Angeles federal court that involves about $1 million of unpaid or even unreported taxes. And then somebody came along, this friend of Biden came along, a friend of Hunter Biden, this Hollywood guy came along and paid millions of dollars. That is totally unpersuasive. The idea that you can get out of a federal criminal income tax case by paying your taxes later, that's ridiculous. The whole idea of deterrence is that people do this because they think they won't get caught. If you take the one person in 50 who gets caught and say, okay, you say, oh, you caught me now? Hey, wait, here you go. Here's some money. I borrowed from my friend. I sold a piece of property. Here's the $1 million I owe you. That doesn't get you anywhere with the IRS. The idea that because he was able to pay from this friend's money, that he's going to get some kind of a break. So you say to yourself, here was a guy who was going to get a misdemeanor and going to get a pretrial diversion. And here were his two problems. Here was why it fell apart, blew up in court. I was commenting on it at the time. I remember it so well. I went back and reviewed it. They said, look, maybe the probation office will be a total jerk. The probation officer will go after Hunter Biden because he's a famous person or whatever it is. You know, that sometimes happens. You think you'd be ahead of the game by being really prominent in the system. This happens to some lawyers who become so prominent. I'm not one of them. There's lawyers who become so prominent that, you know, prosecutors think, oh, well, you know, they're so-and-so, you know. You don't want to be that famous. That, you know, I mean, Johnny Cochran had that problem. As soon as Johnny Cochran walked into a courtroom after OJ, people had all this stuff go through their head, which wasn't about the case, but it was about Johnny Cochran. Anyway, the point that I'm trying to make is that when he turned that down, you think, why on earth would he do it? He couldn't possibly, being acquitted in both cases after spending millions of dollars on his defense was not really a whole lot better than the misdemeanor. He's going to be on misdemeanor probation. He wasn't going to go to jail. So that was the one thing. The probation office may be a real jerk. So they said, Judge, we want you to decide in the first instance whether there even is a probation violation. She said, that's not my job. I'm a federal judge. Besides, I decide whether there was a federal probation violation as the final arbiter. I'm going to be the first arbiter. I'm the final arbiter. I'm the judge. Probation office sends me a report that says you're in violation of probation, Hunter, and the person's a jerk. There's no basis for it. I'm going to throw it out. That's it. I'm going to adjudicate it. So what else you got? What's your other problem? And the other thing was they said that the agreement had been written in a way, and the defense thought they were being very clever, that this would give him immunity in the future as to some China dollars, as to some investigation with daddy and all this kind of stuff. And they made it very clear, no, it's not giving you immunity for that. And that's when Hunter Biden's attorney said no deal. It was not worth losing that deal. It was not worth losing that deal over either one of them. They should have walked over to the prosecutor. I would have, you asked any criminal defense attorney, posit these facts. What would you have done? I'd have said, you know what, the probation thing, you're right. The probation office, the judge is going to decide that. And the other thing, guess what? I didn't do anything wrong. You guys come after me for some kind of corruption in China with my daddy, the Biden crime family. Bring it on. Bring it on. We'll defend that. But it was obvious that that agreement, if it did not have that interpretation, why on earth would the special prosecutor have agreed, we're going to give you a pass on the China stuff with your daddy, Ukraine, all that kind of stuff that Congress is investigating, the Republican Congress going nowhere. They have a star witness who blew up in their face. They're nowhere. That's garbage. And to lose that deal, Mark, over not having immunity for something that they weren't really in danger of was so arrogant. It was so overplaying their cards. And I think to myself, I'm a Biden supporter, Joe Biden supporter. I think to myself, why on earth would Hunter have turned that down? Except he thinks, maybe he thinks wrongly, that he thinks that he's never really facing peril of prison anyway.
That is such a well-argued and well-reasoned argument. Wow. Because
and it was on you. This wasn't rehearsed. I sprung this on you.
It was excellent, and it makes total sense. And it doesn't reflect well on Hunter, to be honest. It doesn't reflect on, I mean, you know, there's an implied arrogance or whatever you overconfidence, maybe, but
including recently, not 6 years ago, not 5, 6 years ago. Everyone should be sympathetic what happened to him 5, 6 years ago. And I think in a perfect world, he wouldn't have been charged with this, because it seems to me like this was, Trump always says they're looking for me. They're not looking for a crime. This did look a little bit like they were looking for Hunter, not looking for a crime. This form thing is really weird. It's true. It's not prosecuted much. It seems almost like selective prosecution. But, if they're going to bring that motion that it was selective prosecution, I think it's been denied. As a legal matter, selective prosecution, very, very hard to prove.
In our last minute or so, I really just don't want the visit to go away without us talking about the Merrick Garland contempt of Congress vote. Republicans are punishing him for refusing to turn over the audio related to President Biden's handling of classified documents. So the rich part of this is that some of the people involved in this very action to hold Merrick Garland in contempt of Congress are themselves in contempt if you hold the same standard, that is to say, honoring a subpoena that you were served with, because it's just the fact that you've got, most of that crew out of GOP land voting in contempt of Congress for Merrick Garland, who they themselves just didn't honor the same kind of subpoena. You could almost erase the name of Merrick Garland and put in the name of Jim Jordan or whomever. Could you speak to this, and what does contempt of Congress mean? If you look in your Funkin' Wagnalls, under the word hypocrite, you'll see a photo of Jim Jordan. It's astonishing. This the hypocrisy that we're talking about. Number one, Attorney General Garland hasn't done anything worthy of a contempt citation. Number two, no one is going to prosecute this in the Department of Justice, and no one should prosecute this. And I don't know if they try to impeach him, which I guess is the next thing they could try to do, like they tried to impeach Mayorkas. It'll be, voted down in a second by the Democratic Senate, as it should be. The only thing that's sort of an issue, Mark, is that they do normally turn over recordings, right? So they've turned over a transcript of what President Biden said during the 5 hours of interviews with the special prosecutor, but they haven't turned over the actual audio. Now, what they say is that, well, we need to hear the audio. I mean, this is abnormal. You turn over a transcript, you should turn over the audio. Like if one of your listeners said, Mark, you're showing the transcript, why don't you play it? There is sort of this logic, and that's why the Republicans think they can get away with it. They're going to argue, why don't they play it? There must be something terrible on it. But there's nothing terrible on it. And what they want to do is there's going to be situations where Biden pauses, where he seems to be doddering in his speech. And they want to play that over and over again during the campaign, just like the Democrats want to play those 3 minutes of Trump the other day. If you want to see somebody who really does not have the mental acuity to be the president, listen to Trump for 3 minutes about the outboard motor, he'd rather be electrocuted than eaten by a shark. Yeah. On and on it goes. But this is why they really want it. And what the Department of Justice says is, look, whatever you're investigating what? Whether Weiss did his job properly. You're investigating whether Biden should have been charged because Biden had those documents at home. How does hearing him say the things that you have a transcript of possibly be relevant to that investigation? So they're standing on relevance, and courts do that. If you don't have any purpose with a court why something is relevant, they say if all you want to do is make a big show, and how is that relevant? Maybe it's relevant to how with it Biden is, but that's not what Congress purports to be investigating. They purport to be investigating whether Weiss properly did his job or whether Biden really should have been indicted for having those documents, which, of course, to state the obvious, the man who should be indicted for wrongly taking, wrongly holding, and obstructing justice with regard to top national security documents is Trump, the guy that these hypocrites race to defend, even with all the things that he did at Mar-a-Lago. So to me, it's just totally politics. And now, well, it's clearly totally politics. But what you're not doing your job. You're not doing your job as Attorney General if you don't get indicted. They indicted the last three.
They've indicted Holder. They indicted Holder, they indicted Barr, and now they've indicted Garland. It's like you've totally failed at the job of being America's Attorney General if you
You're
haven't
not
been
doing your
indicted by
job as
the other
Attorney
party.
General unless you're getting indicted is the greatest line of the day. But it's obviously political, but what you said is no, but there is a legally defensible position here for Merrick Garland to not release that audio.
Right, and it has no relevant purpose to anything that Congress is investigating. And by the way, if I said indicted, held in contempt, all three were held in contempt by the other party when they were in control of the House of Representatives. Holder, Barr, and now Garland, held in contempt by the opposing party in Congress. So it's really become par for the course. I don't think anyone's paying attention to this. I think people are still interested in Trump and what Trump's sentence is going to be. I predicted already that I don't think that he's going to get any prison time or even home detention time. But he had to have an interview with with the pre-sentence officer, which is so amazing, Mark, because this is what I do for a living. I go to those interviews. It's like suddenly we're talking about pre-sentence interviews and the former president of the United States. It kind of snaps your head back.
But your clients can't Zoom in. They have to actually go, don't they?
Actually, during the pandemic, they could Zoom in, and I always go to the interview with my client. That's totally normal. I don't know, maybe not under New York law. Maybe that's a little unusual. But certainly,
do you typically say anything in those back and forth, or are you just kind of there in the room?
I'm there in the room, but if we're getting into an area, what normally happens is you don't have your client talk about the offense. Either your client went to trial. Of course, if they're found not guilty, you don't need to go to one of those pre-sentence interviews. I've had 4 of those where my clients were completely acquitted. That got them out of court completely, including the pre-sentence interview. But if there's a conviction, yes, you have the pre-sentence interview. Then you don't want your client to talk about the case because you want to preserve the record. Maybe your client hasn't testified at the trial. Now you're going to suddenly you're going to suddenly talk about the offense that you haven't talked about. You're going to talk about it at the pre-sentence officer. Or your client has pleaded guilty. If your client's pleaded guilty, there's a factual basis in court. Normally it's written out. My client admits that he did X, Y, and Z. And so you don't want to talk about the offense then either, because there's a record and you're relying on the record either for sentencing or you're relying on the record for the appeal. You don't want to make more of a record by talking about the offense. So in federal court, they understand that the client's not going to talk about the offense at all during the pre-sentence interview. And so one of the things that you're there as the attorney to do is to monitor it. I want to say one last thing, because this is how Machiavellian I think Trump is. I think Trump may want to talk about some things, like I did not sleep with Stormy Daniels, and malign Stormy Daniels, figuring that someone's going to leak that report. And he's going to say, no, you can't sue me for defamation. I was forced to speak. I was asked a question. I had to answer it. The judge forced me to go to the pre-sentence interview, and he's going to try to get around the defamation. My prediction is that he'll make defamatory statements in there and claim that he was forced to speak because the judge ordered him to participate in the pre-sentence interview.
That is wild. That is great. David, I love our time. I know it's done. Thank you for being so generous with your opinions, with your analysis, and with your time. Really enjoy it.
I'm going to hear from Hunter Biden's fans, aren't I? I was trying to give my best. I was trying to give my best legal analysis. That's my best legal analysis.
Yeah, you make a pretty good case for the fact that he's expecting the pardon, and he will likely get it. All right, David. Appreciate it. David Katz, everybody. Thank you. Hi, it's Mark, and I thought that was great. Hit the notification bell. You'll know whenever there's a new video being dropped, and please subscribe to our channel to help us save the universe.